Apologies for keeping you waiting.
Not at all. May it please your lordships, my learned friend followed a particular course with his submissions, starting with jurisdiction under Article 5 of the Convention. If I may, I'll follow the same course. So it's, I think in the list of issues it's down as issue 2, but I'll start with that. Just a couple of general observations. There's no appeal from the learned judge's conclusion, and was no appeal in the Court of Appeal, from his conclusion that there's a good arguable case that the conspiracy which we allege was hatched in England. We say, therefore, England was the place where the harmful event occurred, as established in the European jurisprudence. Often referred to as Lim B as the beer test. Now, what I'd like to do to begin with is just show your lordships some of the leading decisions, particularly in the European Court of Justice, or the CJEU as it's now called, for two purposes really. Firstly, to show your lordships how the court analysed the questions that were the relevant questions before them, but also to see how they applied it on particular facts, because it's the application of the test in particular facts, which in our submission is quite instructive. So could I start with the beer case itself, which I don't think your lordships saw this morning, which is in the core bundle at tab 5. And this was a case where some salt, I think it's described, or residuary salt, was discharged into the River Rhine in France, and then travelled all the way through Germany and reached the claimant's seed beds or plant beds in the Netherlands and caused damage in the Netherlands. And the focus of the European Court of Justice, as it then was in this case, was on looking for the first relevant event for the purposes of the claim that was being made. And they were encouraged to take that line, we think, by submissions made on behalf of the Netherlands government, which are on page 443 of the bundle, or the electronic numbering, internal page 724.
Yes, you're absolutely right to refer to the electronic, but somehow
something's gone awry.
I think I can say your bundling. Anyway, the bundling has
yes.
failed.
Well, as far as it was, I apologise on behalf of.
Lord Briggs seems to be happy.
Mine seems to be singing as sweetly as a bird.
Yes. No, but the electronic numbering is fine on the screen, but it's just not on the bundle if one's using it.
Oh, no, it's not on the bundle, no.
Right, sorry.
Never.
There's no problem with the screen.
724, yeah.
Yeah, and I just want to refer to the submissions made by the government of the Kingdom of the Netherlands, which is in the top half of that page, in particular.
Yes, where the event giving rise to the damage took place.
Yes, and the reference against the letter D, where the government referred to the court for the place of the first act and the court for the place where the damage occurred. So that's the first reference we've seen to first act or origin or something originating.
Right.
And then if we go on in the judgment, which begins on page 447 of the electronic bundle, 728 of the internal numbering, under the heading Law.
What's the electronic page number?
447, my lord.
Thank you.
After reference on 448, that's over the page to
Paragraph?
the conventions, that's paragraph 7, Article 5. Moving on to 449, paragraph 13, that's page 730 of the internal numbering. In the context of the convention, the meaning of that expression, the place where the harmful event occurred, is unclear when the place of the event, which is at the origin of the damage, is situated in a state other than the one in which the place where the damage occurred is situated, as is the case in pollution. And then 14, form of words, place where the harmful event occurred, leaves open the question whether it's necessary in determining jurisdiction to choose as a connecting factor the place of the event giving rise to the damage or the place where the damage occurred. And then 15, as regards this, it's well to point out the place of the event giving rise to the damage, no less than the place where the damage occurred, can, depending on the case, constitute a significant connecting factor. And then liability in tort delict or quasi-delict can only arise provided that a causal connection can be established between the damage and the event in which that damage originates. That word is often used, where damage originates. And then in 17, they say that taking into account the close connection between the component parts of every sort of liability, it doesn't appear appropriate to opt for one of the two connecting factors over the other, so both can apply. So we have limbs A and B. And then 19, thus, the meaning of the expression place where the harmful event occurred in Article 5.3 must be established in such a way as to acknowledge that the plaintiff has an option to commence proceedings either at the place where the damage occurred or the place of the event giving rise to it. And that phrase is repeated in paragraph 24 on internal page 731, electronic page 450, at the end of paragraph 24, and then the result is stated in paragraph 25. The result is that the defendant may be sued at the option of the plaintiff, either in the courts for the place where the damage occurred, on the facts of that case, the Netherlands, or in the courts for the place of the event which gives rise to and is at the origin of that damage. Again, using the word origin. And that's repeated in the formal finding at the bottom of the page. So the focus was very much on the first act in a chain of events, or the origin of the damage. Now, you were referred to Cheval, but I can't, I'm afraid, remember whether your lordships were asked to turn it up. Cheval is in tab 22 of the same bundle, so in the electronic report it's page 889. And this was a defamation case where Francois, the newspaper, was alleged to have defamed a lady from Yorkshire, and by reference to activities which had taken place in France. And the question was whether proceedings could be brought in England as well as in France. And the answer was that proceedings could be brought in France in respect of the defamation because that's where it was first published, but proceedings could also be brought in England in respect of the damage suffered in England.
Yeah.
Now, just to see how the court phrased the relevant test on internal page 53, electronic page 924.
That's the Advocate General.
Sorry, yes, I've got that wrong. It's internal page 932. Sorry, internal page 61, electronic page 932. Yep. Paragraph 20, after reference to the beer case in the first line, the ECJ says...
It's rise to and at the origin of
yes,
that damage.
and is at the origin of that damage.
Yeah.
And 24, towards the end, only be the place where the publisher of the newspaper in question is established, since that is the place where the harmful event originated and from which the libel was issued and put into circulation. Some reliance was placed by my learned friend in his case on a passage on page 924. That's 94 of the electronic version, 53 internally, paragraph 24. The reference the Attorney General made to the plaintiff always having the option of suing in respect of the whole of his claim before the court of the defendant's domicile and those of the place in which the causal event occurred.
Yeah.
But that, we respectfully submit, doesn't take the point any further or throw any meaningful light on the question. So that then brings us to Domicrest, the decision of Mr. Justice Ricks, which is in tab 10 of the core bundle, electronic page 585. That's the head note. And as your lordships know, that was a case of a misrepresentation or misstatement made in Switzerland and relied upon in England. There was also a contractual claim which his lordship found could proceed in England, but the tort claim for misstatement couldn't. Now, in his judgment, on page 599 of the electronic bundle 562 internally, his lordship referred to the Beer case and other decisions of the European Court of Justice.
Right.
And then dealt with those over the next few pages. Could I ask the court to turn on, please, to page 565 internally? That's 602 of the electronic bundle. At letter C on that page, his lordship points out there's no European court decisions on the application of 5.3 to a case of negligent misstatement, but counsel had relied strongly on a decision of Mr. Justice Steyn in a case called Minster Investments and Hyundai Precision and Industry. He sets out the facts of that case, and against the letter E, his lordship says that Mr. Justice Steyn was conscious of the Beer case, but the other three cases which he'd just cited hadn't by then taken place. His lordship goes on to be critical of the conclusion reached by Mr. Justice Steyn, or at least he didn't reach the same conclusion as to the appropriate test himself. Could I just draw the court's attention to the passage in Mr. Justice Steyn's judgment, which is on page, against the letter H on page 602 of the electronic bundle 565 internally. Mr. Justice Steyn had said, faced with a number of connecting factors with different member states, in a tort case, I'm not attracted by the argument that the decisive connecting factor is always the one which is first in time, even if it can be said to be a condition sine qua non to the commission of the tort. So he went on at the top of the next page to say, towards the end of the first line, in my judgment, common sense and policy considerations require one to ask where in substance the cause of action in tort arises, or what place the tort is most closely connected with. And then after the quotation, Mr. Justice Ricks says, just below the letter E on that page, that reasoning is undoubtedly attractive, but against the letter F, nevertheless, do not feel confident that Mr. Justice Steyn would have been able to reason as he did in that judgment if he'd had the later decisions of the European Court before him. He rejected the argument that the decisive connecting factor is always the one which is first in time, and yet Dumes, Cheval and Marinari, each in their own way, emphasise that to look to the later consequences is to run the risk of favouring the forum actoris. They also emphasise that the formula developed in Beer is to be strictly applied, and his lordship explains that. So it's against that background that his lordship, on page 604 of the electronic bundle 567, internally, at the bottom of the page at H, says that he, well, just above the letter H, he's not free to apply the broad test adopted by Mr. Justice Steyn, but must limit himself to the more structured formula adopted in the decisions referred to. Applying that formula, it seems to me that the place where the harmful event giving rise to the damage occurs in a case of negligent misstatement is, by analogy with the tort of defamation, where the misstatement originates. It's there that the negligence, if not every element of the tort, is likely to take place. and for that and other reasons, the place from which the misstatement is put into circulation is as good a place in which to found jurisdiction as the place where the misstatement is based on, even if receipt and reliance are essential parts of the tort. And then further down that paragraph, His Lordship refers just above the letter C to the representor's negligent speech rather than the hearer's receipt of it, as best identifying the harmful event which sets the tort in motion. And rejects receipt and reliance as epitomising the harmful event. So we submit entirely in line with the decisions which I've shown your Lordships from the European Court. His Lordship was looking for an originating event which was responsible for the damage. Now, in our case, and I think I can take this from the Court of Appeal judgment, which is in tab 10 of the core bundle, electronic page 184, we pointed out, and the Court of Appeal agreed, that the approach of Mr. Justice Ricks was approved by the court. Oh, sorry, I'm in paragraph 80 on page 184. Approach of Mr. Justice Ricks was approved by the Court of Appeal in the ABCI Bank Franco-Tunisienne case, and it has been followed in three decisions, or by three decisions at least at first instance. And in two of those cases, the judges indicated that they would have reached the same conclusion themselves. I don't think we've included all the authorities in the authorities bundle, but certainly what they say, and as the Court of Appeal agreed. Now, the ABCI case, which is the first authority,
Is Mr. Justice Ricks in Dominic Crest, where he speaks of a harmful event setting the tort in motion? Yeah. Is he saying, is that just a synonym for what later CJEU case law calls the causal event, i.e.
Yes.
that the event which causes the harm?
Not necessarily the event which causes the harm, but the
relevant event.
The event, the first event which leads to the harm.
Yeah, you say it's the originating event.
The originating event.
Yes.
It's the same.
But setting the tort in motion would be an English law
yes, of course.
concept. But
yes.
The Europeans look to the causal event of the harm.
Yes, but of course there may be many facets for the causal event, and what
you say
we're looking
it's the
for is the originating event,
yes.
as was made clear in the...
Yes, I mean, this is a helpful elucidating judgment which shows that I would be wrong to paraphrase the test you're seeking with a test of real or effective cause or substantive
yes.
cause. It would also be wrong to substitute proximate cause, because that's the other end. That's looking
exactly.
Traditionally at the loss.
Yes.
Although insurance laws got away from that. All right, well, I think we got that's very clear.
Yes,
are you submitting that the originating cause is the same as the facts which constitute the cause of action?
Not all of the facts, no.
Well, or yes. But I mean, is it relevant at all to inquire which facts constitute the cause of action for the purpose of identifying the originating cause?
Well, we think it's unavoidable, because the cause of action is going to be established by reference to a system of law, and the court will have to ascertain what are the relevant facts for the cause of action. So when you have, for instance, a negligent misstatement case, there's a misstatement, and then there's a receipt of the misstatement, and then there's reliance and so forth. So there's a number of facts.
Well, I mean, suppose that you have an action for misstatement against a company, and a direction is given from the company's head office in New York to make the misleading statement the direction is given to someone in England who makes it. I mean, you're not suggesting that in that situation you'd go back to New York.
Not for the direction, no.
So, I mean,
Because the direction, sorry, my lord. The direction isn't part of one of the constituent parts of the tort. The fact that a misstatement was made because somebody decided somewhere that it should be made is not relevant. What's relevant is that the misstatement was made.
well, if I, in country A, instruct my agent in country B to misstate something to somebody in country C, then for the purpose of making me liable, it is relevant that I gave the instruction.
I see the force of that, which is a different concept, but thankfully not our case. Whether we would then run into Meltzer-type problems of imputation of liability, I'd have to give.
I just wonder whether, for European purposes, it matters whether what any of the elements of the cause of action in national law are. You assume that there is a cause of action if national law says so, and you just look at the facts to identify something in a chain as being the relevant one.
Yes.
But, I mean, you seem to be submitting that it's the first in point of time.
Yes. That's right.
I mean, if you take the firing of a gun, it's the pulling of the trigger, you say, rather than whatever happens to the bullet, which may ricochet and go in all sorts of directions. That certainly, in negligent misrepresentation, that seems to be the
Yes.
test, and you say it's the same here.
Yes.
The Austrian case is a parallel. The publication in Germany is what's significant, rather than its
Yes.
accessibility or manifestation all over the world.
Yes.
So the firing of the gun would be the relevant originating cause, whether the action was against the person who pulled the trigger or against the manufacturer of the gun in yet another country who installed a non-functioning safety catch, for instance. In either case, would you distinguish between those two cases? Would you say you go back to the country where the manufacturer was, if that's the basis of the claim?
If there's a claim against the manufacturer, yes.
I see. So in that case, you wouldn't look at the firing of the gun as being the...
No, if the firing of the gun was intentional, then ignoring the safety catch problem, then it would be the place where the trigger was pulled.
But if the complaint is putting into circulation an unsafe gun,
Yes.
that's the relevant event.
The
The firing, the fact that it goes off, is just a sort of manifestation of the unsafety.
Yes.
So this ends up, in reality, as being a test pretty well indistinguishable from Thompson and Distillers, where the test was said to be where the substantial event constituting the cause of action occurred, regardless of where the actual damage occurred.
Well, no, Lord.
That's a bit too close to Mr. Justice Staines.
Exactly. That's my concern about a substantial event, when you have to pick and choose between different parts of the cause of action, whereas the focus of the European Court is on the, as it were, the first step in the chain.
But, is that really their focus? In Mine de Bottas, the beer case, there weren't a series of events constituting the cause of action, save in the sense that the pollution of the river may have occurred several times. It was just the pollution of the River Rhine somewhere in Alsace. And originating was really used there, wasn't it, by contradistinction to the causing of the damage, which occurred probably several days later when the polluted water reached that bit of the Netherlands opposite the fields owned by the grower.
Yes.
So that we don't get, from that case at any rate, the concept that we're looking for the first event. Do you say we get that concept from any other European case, as opposed to the English cases which have sought to interpret
Well, we do say you get that from Cheval.
I was going to say, you
You
probably
rely on Cheval.
Yeah.
Yes.
And we do rely on the case which my Lord has
Hayduck or something, was it?
Hayduck, but we also rely on the case in which Hayduck built, if I can so describe it, which isn't in the court's, wasn't in the court's original files, but should be in a short supplementary clip, which is called Wintersteiger, which is in tab 2. I suspect there isn't an electronic version, I'm afraid, my Lord. So.
There is an electronic version.
There is there? Oh, right. Well, I've got a number 40 at the bottom of my page, so
There's even an
supplemental bundle
electronic
40, if
numbering
that works.
in the case of the supplementary bundle.
So it's a very similar sort of case to Hayduck, but preceded it. Claimant, just look at the facts on the head note D. Claimant, manufacturer and seller of various ski and snowboard tools and accessories and proprietor of a trademark. Defendant was a competing company established in Germany, which sold accessories. And Google was a well-known internet search engine which operated its services under country-specific top-level domains, which enabled users to obtain results. And the defendant registered the word Wintersteiger for Google's referencing service, but limited the registration to searches carried out via the top-level domain for Germany. And just below the letter E, the claimant, the Austrian manufacturer, brought an action in Austria for infringement of its mark, contending that the Austrian courts had jurisdiction to determine the claim. And the court said that on page 46, paragraph 32.
This is electronic 46, is it?
Electronic 46, bottom right-hand corner, internal 156, paragraph 32. It's in particular established that the place where the event giving rise to an alleged damage occurred may constitute a significant connecting factor, since it could be particularly helpful in relation to the evidence and the conduct of proceedings. And then in 34, in the case of an alleged infringement of a national trademark registered in a member state because of the display on the search engine website of an advertisement using a keyword identical to that trademark, it is the activation by the advertiser of the technical process displaying, according to predefined parameters, the advertisement which it created for its own commercial communications, which should be considered to be the event giving rise to an alleged infringement, and not the display of the advertisement itself. So it's where...
That suggests that what we're looking at is not so much where any particular element of the cause of action occurred, but where the process by which the actual damage was caused originated, even if that was not the place where whatever act that gave rise to the liability happened.
Well, it was the first act which led to liability, but the liability wasn't established until the advertisement itself was displayed. So it is a relevant act which led to liability.
It's the place where you do that which causes the offending image to be displayed. That's the point they're getting at, isn't it?
Yes.
And that's not necessarily the place where any of the facts constituting the cause of action necessarily happened. Often it will be, but it not necessarily.
No, I accept that, my Lord. It was the upload may not have led to an infringement of the copyright, although it seems highly unlikely that it wouldn't have done, because everything thereafter was presumably fairly...
Yes, but we're looking at the upload and not at anything prior to that, even if things prior to that are critical elements of the cause of action.
Yes. So that was the next case. Now, Melonophen referred to the Meltzer decision, but I don't think he took your lordships to it this morning, so I won't either, unless your lordships wish me to. It's in tab 8 of the core bundle. It's a rather peculiar case because claim that the English company wanted to bring in Germany was against another company, which has been said to assist the German supplier, but the German supplier wasn't joined to the proceedings. The reason why we submit the decision isn't material in our case is because in our case we have, as wasn't challenged on appeal below, a good arguable case that Mr. Ablyazov and Mr. Khrapunov acted within the jurisdiction of this court, and in any event we're not relying on any harmful event being imputed to Mr. Khrapunov. We say he was a party to the harmful event, namely the conspiratorial agreement. The Meltzer case was referred to by the European Court in the cartel damage decision and distinguished. Perhaps we should just see that. So cartel damage, you saw this morning in tab 6 of the core bundle. On page 502, that's page 502 of the electronic bundle 957. Internally, paragraphs 43 to 45 are, in our submission, the critical paragraphs. And the problem in that case was the court couldn't discern where the cartel agreement had been concluded, and therefore went on, as this court pointed out, to fashion a rule as regards jurisdiction in relation to limb A of the beer test. But it seems clear that if the court had been able to ascertain where the cartel had been concluded, then that would have constituted, in the court's eyes, the place of the event giving rise to the loss.
Yes, I mean, what you take from it, as I understand those paragraphs, is that it's the collusive agreement rather than its implementation when a member of the cartel refuses to sell at anything other than the agreed price. That is the causal event.
Yes, and that is, we submit closely analogous to our situation. And they distinguish Meltzer in paragraphs 48 and 49 further down that page. Well, they didn't regard Meltzer as in any way an obstacle to finding jurisdiction under limb B on the facts of that case. Now, the next case I was going to refer to, probably don't need to turn it up, is the AMT case itself, which I know your lordships are very familiar with, not least my Lord Hodge. That was, of course, a limb B. A limb A decision, not a limb B decision. In that case, the event occasioning damage was the inducement in Germany to break the contracts with the English company. And that's why limb B was of no assistance to the claimant in that case, because it led to jurisdiction being in the German courts rather than the English courts. I think that's clear from paragraph 23, which is on electronic page 386, internal page 864.
Paragraph?
Paragraph 23, first sentence, where my Lord says, there's no dispute in this case that the event occasioning damage, the alleged inducement of the former clients to commence the German legal proceedings, occurred in Germany. Therefore,
we weren't considering the issue that's before us today, but I suppose that sentence, as far as it stands, looks to the inducement rather than the implementation by commencing proceedings.
Yes. So we infer that that's why the issue was whether it was a limb A was satisfied, not limb B.
Yes.
In fact, So that's AMT. Now, in Malone and Friends' case, there are a number of criticisms of the Court of Appeal's decision on this issue. In our submission, the Court of Appeal was right for the reasons which it gave in paragraphs 72 to 87. That's electronic pages 182 to 186 of the core bundle, tab 10. Not going to go through those, but could I ask the court please to turn up Malone and Friends' case in tab 7 of the core bundle, so that I could deal with some of the points that are made there, starting with C1 on page 100 of the electronic version of this bundle, internal page 18. In our submission, Malone and Friends' submission gets off on the wrong foot because he says in paragraph 53.1 that the Court of Justice jurisprudence requires identification of the event which caused the alleged damage, whereas in our respectful submission, from what we've seen, it doesn't. Not the event. The focus isn't on the event which caused the damage. The focus is on, we say, the origin.
Which originated the alleged damage.
Yes. And so one doesn't have to get into questions, whether factual or legal, of what exactly was the cause of the damage. There was no damage to the claimant when the salt was put into the River Rhine. As my Lord Briggs has pointed out, the damage wasn't suffered until no doubt several days later and many hundreds of kilometres downriver. But at the actual point of introduction, there was no damage to the claimant. But nonetheless, the claimant could sue in France, because that was an originating event. And then in section C2, on the next page of Malone and Friends' case, in paragraph 55, he says the case law of the Court of Justice establishes that the focus is on identifying the event which best satisfies the description of the event which causes the damage.
Actually, mine de potasse, they could sue in Netherlands, not surprisingly.
I'm sorry, my lord, I didn't hear that.
You said mine de potasse established they could sue in France. In fact, not surprisingly, since they were a Netherlands firm, they were interested in suing in Netherlands. And
Yes.
so it upheld that, didn't it?
It gave them a choice.
They could have sued.
Could have sued in France,
They
of
would
course.
get,
Yeah.
it's a choice case. Yeah.
Yes, they could sue in France because that was the place of the originating event.
Right.
They could sue in Netherlands because that's where they suffered damage.
Right.
So both government submissions were upheld.
Yeah.
So, Malone and Friend, one should note how Malone and Friend expresses the point in paragraph 55, because he's says that the focus is on identifying the event which best satisfies the description of the event which causes the damage, and then he refers to a number of references to events causing the damage in a number of authorities. When one looks at those authorities, in fact, in 5 of the 6 cases in our respectful submission, the authorities in support of our proposition, not Malone and Friends, and in the 6th it's neutral. So let me just take that quickly. The first one is Zuid Chemie, which is in bundle 5 at tab 17, which is electronic page 3061. And what happened there was a Dutch claimant had a claim against, a Dutch claimant that produced fertilizer had a claim against a Belgian defendant for having produced the wrong admixture of chemicals for it to use in its production of the fertilizer. Now, the bad mixing, if I can so describe it, had happened in Belgium, but the fertilizer was actually put together in the Netherlands, and the Court of Justice held that damage was caused to the claimant in the Netherlands, so it could sue in the Netherlands under Lim A, but it was common ground that the place of the event giving rise to the damage for the purposes of Lim B was Belgium, not the Netherlands. And we can see that on page 3066 of this bundle, paragraph 25, so that's internal page 270. Common ground between the parties to the main proceedings, as stated, paragraph 13 of the present judgment, that Essen, that's in Belgium, is the place
Sorry,
of
you're
the
reading
event.
from paragraph.
Paragraph 25, my lord.
Sorry, can you give me a page number?
Yes, 3066.
Thank you.
Paragraph 25. Common ground between the parties to the main proceedings, as stated in paragraph 13 of the present judgment, that Essen is the place of the event giving rise to the damage. They disagree as regards the determination of the place where the damage occurred, whether it was Belgium or So the event giving rise to damage was the admixture before it left the defendant's factory. That was an originating event. So we say that supports us on Lim B. Hayduck was the case where photographs were put on the German website and damage was held to have been suffered by the claimant in Austria. But the causal event was the activation of the process for the display of the photographs. I think we saw that this morning. Just have another quick look in tab 15. The report begins at page 3021, that's internal page 560. And the relevant paragraphs are 24 to 26, which are on 3025 to 6.
Sorry, I think I misheard your page number.
3025 to
Thank
6,
you.
sorry. After reference to, in 23, to Zuid Chemie, with what case we just looked at, the European Court says, in a situation such as that at issue in the main proceedings, in which the alleged tort consists in the infringement of copyright or rights related to the copyright by the placing of photographs online on a website without the photographer's consent, the activation of the process for the technical display of the photographs must be regarded as the causal event. The event giving rise to a possible infringement therefore lies in the owner's...
Which paragraph are you reading from?
24,
24.
on page, internal page 564. The activation of the process for the technical display of the photographs, and very much at the outset, is the causal event. And then the next case, which my learned friend cites, is the Foley and Fisher case, which is in tab 14. So again, just to round off on Hayduck, we say that observation supports our case. Foley and Fisher in tab 14, that's 2987, my lord, in the electronic bundle. That's the first page, and the relevant passage is on pages 3010 and 3011. And that's paragraph 52. And in essence, what had happened in that case was a party had brought proceedings for a negative declaration in a state which it said was a state which had jurisdiction under Article 5.3. And the question was whether a claim for a negative declaration was a claim to which Article 5.3 applied, and the answer was, in paragraph 52, yes. But that doesn't help us with respect with the question which we're facing, so the decision really doesn't help one way or the other. So that's the one that we say is neutral. The other three we say support us. Kalasa, which is the next one, is in tab 16. And the relevant passage there is paragraph 53, which is on page 3057, internal page 762. The facts there were that an Austrian investor had purchased some investments through his Austrian bank. The Austrian bank had acquired the investments through a German bank from Barclays, I think, from a branch of Barclays in Germany. And the question was whether the claimant was entitled to sue Barclays in Austria. The answer was yes, he was, because the damage that he suffered was suffered in his bank account in Austria. That's Lim A. But so far as Lim B is concerned, paragraph 53 on page 3057 is relevant, where they say, as regards the events giving rise to the loss claim, namely the alleged breach by Barclays of the obligations relating to the prospectus and information for investors, it should be pointed out that the acts and omissions that might constitute such a breach cannot be considered to have taken place where the investor who claims to have suffered loss is domiciled, given that there's no information in the file to show the decisions regarding the arrangements for the investments proposed by Barclays and the contents of the prospectuses were taken in the member state in which the investor is domiciled, or that those prospectuses were originally drafted and distributed anywhere other than the member state in which Barclays Bank has its seat, in other words, the UK. So there was no possibility of Austria being the case where the event giving rise to the damage suffered for the purposes of Lim B. So again, in our submission, this is a case which, on analysis, supports our argument, not Malone and Friends. And then the last two cases that are referred to in that passage of Malone and Friends case are the cartel damage claim, the Cheval case, which we've already looked at, where we've submitted that both of those support our case. So there is no support for Malone and Friends theory in those cases, and 5 of the 6 are support our approach to Lim B. And then moving on in Malone and Friends case to C.3, section C.3, that's page 102 of the bundle. He says in the first sentence of paragraph 56 that the correct application of the Lim B test should have led to the conclusion that the place of execution of the alleged unlawful means dealings with assets outside the jurisdiction satisfied the test because it was such execution which caused the alleged damage. Well, no case looks at the execution in terms of the events further down the causal chain, which are much closer to the suffering of the damage. The search is, if I may so describe it, much higher up the chain for the originating event. And in paragraph 57, Malone and Friends says the alleged making of the conspiratorial agreement is an antecedent act which is not in and of itself harmful. So we could say that about the salts being put into the River Rhine in the beer case. That event in and of itself doesn't appear to have been alleged to have been harmful. It was when the salts got down to the Netherlands that they became harmful. And then I can move on, I think, to, well, he makes submissions, page 104 on the cartel damage claim. Well, I've made my point on that. C4, the Court of Appeal erred in focusing on acts giving rise to liability rather than damage, and in our submission, the Court of Appeal didn't. Paragraph 64, Malone and Friends wrong to say that the focus is on that which causes the damage. It's on the event which starts the process, which ends up with damage, ditto what he says in paragraph 67.
But is legal foundation of liability, is that a red herring nonetheless? Insofar as it's referring to domestic law?
Well, as I endeavoured to say earlier, the domestic law defines what is relevant for the purposes of liability, and to an extent, therefore, there has to be recourse to domestic law to see what the relevant events are. But it's probably too far to say that one has to establish the legal foundation for the claim, the legally relevant first event, which ultimately led to the damage, is how I prefer to put it.
Yes. Thank you.
In paragraph 70, there seems to be a suggestion that we're asking the court to create a special rule to accommodate domestic tort law, and in our respectful submission, we're not. And then the remainder of the submissions in this section are about Meltzer. I made my point on Meltzer. C5, and they say the Court of Appeal adopted a second error by adopting the sets the tort in motion test, but for the reasons which I've endeavoured to express, that test is in line with the approach which the European Court itself has taken in many cases. There's a reference in 78 to the McGraw-Hill case, decision of Mr. Justice Cook. What happened there was Mr. Justice Cook applied Domicrest. So McGraw-Hill, that's in tab 5, the authorities. At tab 10, bundle 5 of the authorities, tab 10. The report begins at page 2885 in the electronic version, but the relevant passage is paragraphs 50 to 55. On electronic pages 2894 to 2895, it was another misrepresentation claim. Although, as it happened, in paragraph 55 on page 2895, the court can see that on the facts of that case, the misrepresentation was both delivered and received in the same place. But his lordship relied on Domicrest and didn't suggest that Justice Ricks had in any way got the test wrong. The Anton Durbeck case, which is referred to in that section in our submission, doesn't take the matter any further. It's also referred to by paragraph 82.1. And then in paragraph 82.2, learned friend says, in Chevel and Domicrest, the acts were, so far as the defendant's capacity for action was concerned, complete acts in that there was nothing more for the defendant to do for the damage to be caused. Well, that's not a test which has been set out in any decision that your lordships have been shown or that we have found, namely a test of something can only be a causal event if the defendant has done everything he needs to do in order for the tort or dealing to be established.
It also doesn't distinguish the cartel damage case, does it?
No, it doesn't. I agree. And then C6, the third error, the reliance on the justification and rationale for Limb B. Well, there's no error by the Court of Appeal there because, as we've seen from one or two authorities, the Court of Justice itself tests, or is wont to test the conclusion reached by reference to the rationale. And we set out some, or refer to some of those authorities in our case at paragraph 62, which is core bundle electronic pages 151 to 152. That doesn't mean that the decision is reached applying the rationale rather than the rule. And it's certainly not what the Court of Appeal did in this case.
Sorry, the paragraph of your case.
62
Thank you very much.
of our case, which I think is on 151 to 152
Thank you.
of the core bundle. And then the final point learned friend made was that the Court of Appeal's fourth error was that there was inconsistent jurisdictional rules for economic torts. Well, if there are, then we respectfully say, so be it. There's absolutely no reason why there shouldn't be different rules for different torts. And we know from the decisions in the OBG and total network cases that, for instance, the question of what amounts to unlawful means for the purposes of the two different torts considered in those cases, it gets a different answer. So there are significant differences between the economic torts. What's more important in our respectful submission is that we're applying what we submit is a consistent European Court of Justice approach. And then there's further reference made in that section of Malone and Friends' case to the AMT decision, but I've already made the point against the point made in paragraph 87 of Malone and Friends' case, that the antecedent act of inducement in that case was in Germany. And for that reason, we say the case is, if anything, support for our argument. And then in paragraph 89, there's reference to two other cases, Dolphin Maritime, which is in Authorities Bundle 5 at tab 6, page 2757 electronically, and then Actial Pharmaceutical, Bundle 5 at 2. They were both conspiracy cases, but there was in neither case was there any reason to think that either conspiracy was hatched in England. The first one appeared to have been, looking at the facts, hatched in Turkey. The second one, in Actial Pharmaceutical, was hatched, as far as one can tell, in Italy. And therefore, the focus of the decision was not on limb B of the beer test, it was on limb A, where the damage was suffered. So neither of those cases in our submission is of any assistance when considering what the right answer is on limb B. So, my Lords, for all those reasons and the reasons set out in our case in tab 8, electronic pages 144 to 153, our respectful submission, the Court of Appeal did not err in finding that jurisdiction had been established under limb B of 5. This court does have jurisdiction for the claim we bring. Unless I can assist the court further, those are my submissions on the jurisdictional aspects. So what I'll do now then is turn to the other issue on the appeal, and that's Malone and Friends' submission that there is a preclusionary rule which precludes a claim for conspiracy to injure by unlawful means, where the unlawful means that it relied on are a breach of a court order. In our submission, far from there being a preclusionary rule to the effect that contempt or a breach of a court order can't stand as unlawful means, we say that it's at least arguable that a party can claim damages for breach of a court order or a contempt. Now, the judge and the Court of Appeal both rejected that argument, basing themselves largely on the Barclays Bank decision, which your Lordship saw this morning. We respectfully submit they were wrong to reject the argument. At the very least, we have, I think the test is a serious issue. We could establish a serious issue to be tried.
If this is right, then there were breaches of the court order all over the place, but certainly not in this jurisdiction, pursuant to a conspiracy which you say its common round was arguably made or agreed in this jurisdiction. So what about Mr. Samek's point that you can't have two originating causes of the same loss? What would happen? Would you in some way choose between them or treat one of them as dominant, or is this an objection to your thesis or the consequences of your current submission?
We would suggest, my Lord, that since they are different claims, then yes, you can have different
So it all depends
answers.
how you put it.
Yes. Well, which cause of action you found on.
Yes, I see.
In fact, on the case before your Lordships, we don't actually found our case on breaches of the court order. We're not claiming damages for the breach of the court order. We're claiming damages for the conspiracy. So your Lordships are faced with a conspiracy claim. We've raised the point in answer to the suggestion that the unlawful means relied on are not actionable. We deal
An
with...
alternative is that the European Court might say, as I think I put to Mr. Samek, that the real originating cause of the individual breaches was still the conspiracy.
Yes.
And there's only one relevant cause.
Yes. If Mr. Ablyazov had not fled when he was just before he was to be sentenced, then the claim would have been proceeding against him here in England, because that was where he was then domiciled and where he'd recently received asylum. And if that hadn't happened, the landscape we submit would have looked rather different. But the fact is he has, so we can't, as the Court of Appeal held, rely on the fact that he used to be domiciled here. But that nonetheless doesn't detract from the fact that the conspiracy must have been hatched here.
Yeah, no, that's the basis on which we're all proceeding, I think.
Yes. So we deal with the question of whether you can actually recover damages for breach of a court order in paragraphs 25 to 30 of our case, which is electronic record 126 to 131 of the court bundle. And we address the Court of Appeal's reasons and say why we submit they erred in paragraphs 31 to 36, which is 132 to 136 in the electronic record. Rather than going through those, could I just show your Lordship some of the authorities on which we rely, starting with some old cases which are referred to in the leading textbook on contempt. That's Arledge, Eady and Smith on contempt, which was supposed to be in the main run of authorities, but in fact got a rather truncated version of the extract there. So we included a fuller extract in tab 3 of the supplementary bundle. And this is the edition which came out after the Court of Appeal's decision, which is referred to as we'll see. So on page 50 of this supplementary bundle, there's a heading, the unavailability of financial compensation and possible sources of compensation. Now there's two reasons why we submit it's useful to look at this material. One is to see why we say that there's an arguable claim for damages for breach of a court order. The other is to see whether there's any hint that there's any public policy considerations here which would lead one to think that one couldn't claim damages for breach of a court order, whether by way of a direct cause of action or by way of a conspiracy claim. And as your lordships will see, there is no hint in any of this material. At least that's our submission. And one would have expected such a hint, or more than a hint, an expression, to be found in the leading textbook. And it isn't. Now, page 50, possible sources of compensation. They give 4 in paragraph 14-162, the fourth one being by an action for damages in a civil court. And then they expand on that over the page at 51, damages the modern law, and refer to a recommendation by the Phillimore Committee, which was in the 1970s, which looked at various aspects of the law of contempt, and I think led to the Contempt of Court Act in 1981 or thereabouts. A recommendation was made that compensation should be available in the specific circumstances of reprisals. The authors say it seems that an action for damages does not lie for contempt as such, but don't cite any authority for that. And then on the next page, 14-169, the authors say that damages are unavailable as a remedy in contempt seemed, they put it in the past tense now, I think previously it said seemed clear from the decision of the Court of Appeal in Chapman and Honig. Well, as we'll see, and your lordships may recall from seeing it this morning, that's not what Chapman and Honig decided, or even we submit suggested when one looks at the way in which their lordships express themselves. And then in 14-170, under the heading Early Examples of Compensatory Awards, they say there's a considerable body of case law relating to claims for damages in the context of 2 particular categories of conduct which overlap with contempt. First, in the case in which an officer of the court arrests a person entitled to privilege, long been clear that no action for damages lies, even if the arrest is malicious. That's not particularly helpful. But secondly, it appears that a claim for damages has sometimes succeeded against a witness who fails to attend upon subpoena, although probably only on proof of special damage. It's necessary to consider the extent to which these authorities may still have a bearing on the modern law of contempt before we turn to a more detailed examination of Chapman. And then next paragraph, in early times it was quite common for damages to be awarded to the victim of a contempt by the court which published the contempt law. And then there's reference to some very old cases which my learned friend pointed out this morning. And then in 3 over the page at 53, under the heading failing to comply with a subpoena or witness summons, it seems clear, however, that a party in litigation who has obtained a subpoena for a witness to attend a trial could, in theory, bring an action for damages if he does not attend and give evidence. There remains some doubt, however, as to the scope of such compensation. And one of the questions is, if the case is lost because the witness didn't respond to the subpoena, can damages be awarded in respect of the loss of the case? And that's never actually happened, but as we've seen, Lord Justice Stuart Smith suggested that one might be able to assess such loss by reference to a loss of a chance. And then in 14-174, actions have been brought in the past to recover compensation going beyond this, so as to include the damages of which the plaintiffs have claimed to have been deprived because they lost their action, not overtly on the basis that no action lay for such so the claims have failed, but not because no action lay for such damages. And then Chapman and Honig is addressed. And also the decision of Mr. Justice Tier at first instance. I may be wrong to say that they picked up the Court of Appeal decision. They picked up Mr. Justice Tier's decision because that's referred to in 14-186, but we'll come back to Chapman and Honig. So, in some circumstances, damages have been awarded in the past in respect of a breach of a court order in the form of a failure to respond to a subpoena, and it hasn't been suggested that that wasn't a good cause of action. And no suggestion that there was any public policy reason why such damages or damages for breaches of order generally shouldn't be awarded. Now, in terms of some of the older cases, we refer to these in footnote 13 of our case, which is at page 128 of the electronic version of the core bundle. Internal page 13. And we give the references. There are 4 which are in the bundles before the court. In the interest of time, I'm going to go to only 1, but they're all demonstrate that there is a cause of action for damages, or was recognised to be a cause of action for damages for failure to respond to a subpoena. Which is the best? The one I will go to is the latest one, Davison Lovell, Authorities 2, tab 11.
Electric.
Sorry, where is this in your case?
This is a footnote 13 on page
Oh, it's actually,
128.
I've got it. Now I have it.
And we've got 4 cases there.
Yeah, you're choosing one, yeah.
And I don't think I haven't got time to debate them all with your lordships, but they're all relevant and in point in our submission. We'll go to the most recent, which is 1839, decision of the Court of looks like it's the decision of the Court of Exchequer, please. Davison Lovell, page 1291 of bundle 2. And it's described as a declaration in a case against a witness for disobedience to a subpoena. And in the head note on page 1292 of the electronic bundle 1594, you can see that it was held, secondly, in the 4th line, that it was sufficiently shown that the plaintiff had a good cause of action in the original suit. And the issue that the judgments are contained on pages 1294 to 1295. And they refer back to one of the earlier cases, which is in our footnote, Mullet and Hunt, to say that the claim was a good claim. The problem that had arisen in that case was that there was a suggestion that there was a difficulty with the original claim, that the defendant was supposed to turn up and give evidence in respect of. But that was held as going only to the amount of the damages that could be claimed, not being a bar to the cause of action. We can see that about 10 lines up from the end of Baron Park's judgment. So the particular facts don't matter for present purposes. What matters is a recognition as a good cause of action in respect of loss caused for failing to respond to a subpoena. So in his judgment in the Court of Appeal, as we'll see, Lord Justice Sales referred to our reliance on a case called Cooling and Cox, and said that Cooling and Cox was far too flimsy an authority for the cause of action that we say exists. Cooling and Cox is in tab 8 of the core bundle of authorities. And is to similar effect as the case we just looked at, Lovell and Davis.
We have a page number.
Yes, 534, my lord.
534.
Yes.
And a tab?
Tab 8. Again, it was a case against a witness for not obeying a subpoena. And we can see about 6 or 7 lines down that in the head note, it records that the defendant, without lawful excuse, neglected to appear and give evidence, by reason whereof the plaintiff was obliged to withdraw the record and compelled to pay certain costs to a man named Fuchs. And at the trial of the claim against the defendant, the witness who didn't turn up, but 4 lines below that, at the trial, the plaintiff obtained a verdict on all the issues except the 8th, which was found for the defendant. That issue was whether the plaintiff had a good claim in the original proceedings, and the court went on to find that that wasn't necessarily a bar to the claim succeeding in the second proceedings against the witness. So again, the facts aren't material for present purposes. What's material is that the court recognised that there was a cause of action and that damages may be claimed in respect of it. So it's not just Cooling and Cox that we rely on. We rely on passages in Arledge. We rely on the passages. We rely on the cases which are in our footnote 13.
Well, it seems, I mean, from these cases, it seems to have been assumed that there was a cause of action, and the argument was about technicalities as to whether it was sufficiently pleaded and so on.
That's right. Yes. But if there wasn't a cause of action, one would have expected at least somebody, or at least one of these courts, to say this is not a claim that is
Known to law.
known to law.
It does seem to be rather a special area.
Yes. We've asked ourselves why these claims have only been made in this area, or at least been reported in this area. And it struck us that normally when one claims that the defendant has breached an injunction, the injunction is in aid of a substantive right. And if the injunction has been breached, the substantive right will have been infringed. And if the substantive right will have been infringed, then there's likely to be a claim for damages in respect of that infringement.
It's really the advent of the Moravia
Exactly.
which puts all this on a new footing.
Exactly. That's our submission. When the court starts to grant orders which aren't based on a substantive right, but are based on the desire to ensure that justice is administered in a particular case, when you get injunctions like Moravia injunctions or search orders, or when you get injunctions against third parties in the Chabra jurisdiction, that's freezing orders against third parties. If there's a breach, the claimant may have a complaint, or would have a complaint of contempt, but doesn't have a substantive right to fall back on. Even if one considers the position of a freezing order against a defendant, so a freezing order against a party, the claimant doesn't necessarily need a claim for damages against the respondent to the injunction if the respondent is a defendant in the proceedings, because the consequence will be that assets will be dissipated, but the judgment at the end of the day won't have the ability to be enforced against those assets. I haven't put that very elegantly, but you'll Lordship knows why.
Well, damages wouldn't be much good, you mean, if the asset...
No, it would just be reproducing the element of the judgment which is going to exist anyway on this hypothesis.
Yes, if you can't enforce the judgment against the assets, you won't be able to enforce damages
Yes.
from the injunction.
Quite. It's different when the order is against a third party. And we give the example, which is not, in our respectful submission, fanciful, in our case of a corporate service provider who turns and runs when he's served with a freezing order. This is, in our case, that's the core bundle at tab 8, at page 126 electronically, internally page 11, 25.3. We refer to someone like one of the corporate service providers who features in this case, and I'll show you, Your Lordships, more about him tomorrow. And we say in 25.3, suppose the claimant receives information that the corporate service provider based in Switzerland, some of them are, is administering funds with a value of $500 million for the defendant. Sounds like a lot of money, but in these Russian-type cases, it tends not to be. The CSP arrives in London to receive further instructions, and the claimant serves him with a Chabra freezing and disclosure order in order to deliver up his passport. CSP actually has a bunch of passports in his bag, and he cleverly produces the passport that has the stamp that says he entered Heathrow yesterday, and keeps back all the other passports that allow him to travel freely. That's not an unusual occurrence. As soon as the process server is out of sight, he goes straight to the airport, uses one of the other passports, gets back to Switzerland and says, a plague on all your houses, to the defendant. I'm sending you the money, taking a cut for two, and we can sort it out. And he doesn't respond to the freezing order. And it takes 2 years before the claimant finds out what actually happened, but the claimant does find out what actually happened. Now, the committal jurisdiction is going to be no use against that individual unless he foolishly comes back into the jurisdiction. Because even the European arrest warrant, I don't actually know whether it applies in Switzerland, but assuming it does, that doesn't run in respect of civil contempt. It might run in respect of criminal contempt, doesn't run in respect of civil contempt, so he's not going to be extradited to face a contempt charge. But what would really bite on him would be if there was a possibility of suing him for damages, because he lives in a Lugano Convention territory. You know, he's taken his honorarium. And that could be a target for the claimant. So there's a real need for this sort of claim and an obvious lacuna. And we ask rhetorically, if there is this jurisdiction that we can see in these early Victorian or even pre-Victorian and much older cases, then why should the court not resurrect it for the purposes of dealing with that sort of difficulty, now that we're in a situation where the court is prepared, and obviously rightly prepared, to grant injunctions which aren't in aid of a substantive right. Now, in our...
What's the precondition for a damages claim? What is involved? A breach can occur innocently, can't it?
It can, yes.
Well, are you saying that should give rise to damages?
Can we reserve our position on that? And we see arguments both ways. In our case, what Mr. Ablyazov did was clearly a contempt.
Yes, I mean, how would you introduce any qualification, though, on the liability for breach if you wanted to restrict it to some sort of deliberate?
Well,
what would be the principal basis for a qualification?
The principal basis would be an intentional flouting, or intentional breach, I should say, of the deliberate breach of the order.
What one would say, is there any evidence of that in the witness summons cases? I suppose if a witness fails to turn up because he's ill or something, or is hit by a carriage, they're not going to be liable there.
We haven't seen any reference to that
So
sort of.
but what is it, how does one introduce this qualification as a matter of implication, or it can't be discretion, can it? It's not like enforcing sanctions. It's a cause of action must exist on some defined basis or not.
Yes, we would say that at the very least, when there is a deliberate breach of a court order, then it is, we say, at least arguable, and we go further if we have to and say it's right, that the court can award damages in respect of that action. When you're dealing with a third party, then it would be an intentional interference with the administration of justice by causing a defendant to breach the court's order. Yes, Mr. Aku reminds me that in our, again, I'm afraid we're in a footnote. In footnote 11 of our case, that's electronic page 123, we remind the court of the observation of Lord Stein, in Smith New Court and Citibank, that for more than 100 years at least, English law has adopted a policy of imposing more extensive liability on intentional wrongdoers than on merely careless defendants. So where an intentional or deliberate breach of the order is established.
So which page are you on?
I'm sorry, my lord, I should have given you...
1, 2, 3, you did give it.
1, 2, 3.
Yes, you did. I just didn't find it. That was all.
Sorry,
Footnote
1, 2,
11.
3.
Oh, in the note, yes.
Yeah.
That case is in the bundle. I think there's a reference to it there. So we also refer in this context to a number of later decisions, much more recent decisions, in support of our point, starting with the Fairclough case, which is in bundle 2 at tab 15. Bundles falling apart. That's 1399, my lord, of the electronic version of bundle 2. Fairclough and the Manchester Ship Canal, where some observations were made by Lord Chief Justice Russell. We agree they were obiter, but nonetheless appropriate in our respectful submission. What had happened there was some water had been extracted from the River Mersey. It was said in breach of an order of the court. In fact, the Court of Appeal said that, that the order hadn't been breached. But they say Lord Chief Justice Russell says at the bottom of the page, at the bottom of the left-hand column, where the court is satisfied that the conduct was not intentional or reckless, but merely casual and accidental and committed under circumstances which negative any suggestion of contumacy, while it might visit the offending party with costs and might order an inquiry as to damages, it would not take the extreme course of issuing an order either of commitment or of sequestration. So that goes further than I've just gone in my answer to my lord, because he recognised there that it might be inappropriate to punish a defendant who was careless, but there may be scope for ordering an inquiry as to damages. So we don't need to go that far because we say what...
So this is a case on ordinary breach of an order.
Yes. And then bundle 3, authorities bundle 3 at tab 20. this is a decision of the Restrictive Practices Court given by Mr. Justice McGaw. And again, the facts don't matter. It was there was an allegation that some tyre manufacturers had.
Have I missed another page?
Oh, I'm sorry, my lord. It's 1587.
Thank you.
Some tyre manufacturers had entered into an agreement that infringed restrictive practices and had carried on with their agreement, or with a new agreement, notwithstanding an order of the court that they shouldn't. And again, obiter, but nonetheless worth recording, on page 1612, that's internal page 1162. So 1612 of the electronic version, against the letter G, the court said, "We are also of the opinion that just as the court can require at least payment of damages where there's been a breach of an injunction by a party to litigation between two individual citizens, so also where the injunction or undertaking is given in litigation between the registrar as representing the public interest and an individual or a company, the court, in imposing a financial penalty, may take into account, in addition to other factors, the injury to the public which must be deemed to be involved in the breach." So either way, it can take account of the injury, but an acknowledging that the court may direct the payment of damages where there's been a breach of an injunction in private litigation. And then that statement was set out and accepted as accurate by Mr. Justice Plowman. I don't think we need to turn it up because that's what he said. He accepted it as accurate. In a case called Vine Products, which is in Bundle 4 at tab 45. But can I ask you to go in Bundle 4 to tab 43? Oh, sorry, I should have given the electronic reference to that passage. It's page 2304. That's Mr. Justice Plowman's decision. Then in Bundle 4, we go to tab 43. Please, that's 2240. The decision of Mr. Justice Mustle in a case which is referred to as the Messiniaki Tolmi. And we can see this claim arose out of an arbitration, but towards the bottom of the right-hand column of the head note on page 2240, we can see that the fourth item of claim was for damages for wrongful inducing and or aiding and abetting the buyers to act in contempt of the High Court, and in particular in respect of orders made in the High Court in October 1980 in relation to a particular agreement. So there'd been an injunction in terms of an agreement, and that had been allegedly breached, and a claim was brought for damages. And application was made to strike out the claim, and at page 2245, that's internal page 671, in the left-hand column, His Lordship said in the paragraph that begins about a quarter of the way down the page, the second application that's to strike out need not be discussed at length. It is at least arguable that there exists a civil cause of action to recover damages for an act amounting to a contempt of court. And it's at least arguable that Mr. Sue's participation in the events previously summarised did amount to a contempt of court. In the end, counsel for Mr. Sue accepted that the claim was not so manifestly insubstantial that it could properly be struck out. So His Lordship thought it was at least arguable that a claim could be brought for damages for contempt. And then also in that bundle, back one tab to tab 42.
One last, if you take it very quickly, yes.
the decision of Mr. Justice Skinner in TDK Tape Distributor Company. What happened there was
Sorry,
that...
tab.
Page.
Sorry, tab 42, page 2233. I'm so sorry, my lord. 2233.
Internal?
Internal. Page 141 is the head note.
Yeah.
What happened there was, in breach of a freezing order, a defendant had failed to disclose some assets, and he'd paid out of the undisclosed assets monies to his solicitors, and his solicitors had taken the money in payment of their fees, or at least some of it, and a claim was brought against the defendant and the solicitors, I think. And the solicitors were ordered by his lordship to repay the money which they'd taken from the monies which had been paid to them in breach of the freezing order.
And the solicitors were ordered to pay the monies to the plaintiff's solicitors. The solicitors who got the fees.
Yes, that's right.
Well, that's a sort of damages claim. You say.
We say it looks like it's either damages or unjust enrichment, but I think they had to pay interest as well. We can see that at 2239 in the last paragraph. What?
But isn't
Right.
117. 147. So
This is a
it looks
repayment
like
this is a repayment by officers of the court of money they only had as a result of a breach of the court's order.
yes. So I suppose one could
Quite a
rationalise.
long way to say that underlies a general right to damages.
Yeah, well, I agree, my lord, and his lordship didn't articulate the basis for requiring the solicitors to repay the money with interest, but it may be a recognition of the jurisdiction, or it may be a recognition of some other jurisdiction. I don't think his lordship put it on the way in which your lordship put it to me, but I'll have another look at that overnight.
Thank you very much indeed. Well, we'll adjourn then until 10 o'clock tomorrow morning. You're well inside the time limits, I think.
So.